COVID-19 is just one of the many epidemics to have shaped human life throughout history, changing how we live and move. Because their effects are seldom limited to one country or region, how societies prevent, manage, and recover from an epidemic is inevitably influenced by international law. What needs to be understood is whether the current international legal framework is equipped to deal with pandemics such as the COVID-19 epidemic. International pandemic law, as such, does not exist. Instead, multiple fields of international law bear upon the management of infectious disease controls. These range from international health regulations and human rights to intellectual property rights and biosecurity law. However, COVID-19 has resulted in questions being raised regarding the efficacy of the international legal system. For instance, concerns about equitable global access to vaccines has led to appeals for suspension of or reform of intellectual property law. Currently, 3 pillars of international law are applicable to international pandemics. The first are international health regulations, which are binding on the 196 member states of the World Health Organization. These are designed to prevent, protect against, control, and provide a public health response to international spread of infectious diseases. International health regulations impose 2 main obligations on states. Number 1, the most immediate is to notify WHO of an extraordinary event that could constitute a public health emergency of international concern. The second, more long-term obligation is for states to build core capacity in their health systems to detect infectious diseases and to respond effectively to those diseases. COVID-19 has shown that states have fallen short in implementing their obligations. Post-COVID-19, there have been calls for reform of the international health regulations and the WHO structure as well. The second pillar of international law applicable to pandemics is international human rights law. This focuses on the right to life and the right to health as embodied in the Universal Declaration of Human Rights, the Constitution of the World Health Organization, and various global and regional treaties. The International Covenant on Economic, Social, and Cultural Rights specifically states that it is applicable for the prevention, treatment, and control of epidemic, endemic, occupational, and other diseases. In the realm of pandemics and international human rights law, there are permissible restrictions on certain human rights, such as freedom of movement and freedom of assembly in a public health emergency, as well as dramatic step of formal derogation from human rights treaty obligations. Lastly, the third pillar of international law applicable to pandemics is trade and intellectual property law. The World Trade Organization creates exceptions to free trade obligations in order to protect public health and public welfare. It addresses the question of whether states may restrict exports of medicines or medical equipment. The WTO Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS as it is commonly known, also plays a crucial role in innovation, promotion, and regulation of medical goods and related equipment by governments and stakeholders to tackle a pandemic. For example, the TRIPS agreement allows compulsory licensing and government use of a patent without the authorization of its owner under a number of conditions aimed at protecting the legitimate interests of the patent holder and the public at large. These are just some of the main areas of international law that regulate pandemics. Having identified the gaps, we need to think more holistically of an overarching approach to pandemics so that cross-cutting issues and critical gaps are addressed by a comprehensive and consolidated international legal framework.